Board of Regents of the University of Wisconsin System versus Southworth. One word. Justice Kennedy delivered the opinion of the court. Respondents are a group of students at University of Wisconsin. They brought a First Amendment challenge to a mandatory student activity fee imposed by petitioner Board of Regents of the University of Wisconsin and used in part by the university to support student organizations engaging in political or ideological speech. Respondents object to the speech and expression of some of the student organizations. Relying on our precedents, which protect members of unions and bar associations from being required to pay fees used for speech the members find objectionable. Both the District Court and the Court of Appeals invalidated the university student fee program. The university contends that its mandatory student activity fee and the speech which it supports are appropriate to further its educational mission. We reverse. The First Amendment permits a public university to charge its students with an activity fee to fund a program to facilitate extracurricular student speech. The program is viewpoint neutral. We do not sustain, however, the student referendum mechanism of the university's program, which appears to permit the exaction of fees in violation of the viewpoint neutrality principle. As to that aspect of the program, we remand for further proceedings. Section 1. It seems that since the founding of the university, the university has required full-time students enrolled at its Madison campus to pay a non-refundable activity fee for the 1995-1996 academic year, when this student was, the activity fee amounted to $331.50 per year. The fee is segregated from university's tuition charge. Once collected, the activity fees are deposited by the university into the accounts of the state of Wisconsin. The fees are drawn upon by the university to support various campus services and extracurricular student activities. In the university's view, the activity fees enhance the educational experience of its students by promoting extracurricular activities, stimulating advocacy and debate on diverse points of view, enabling participation in political activity, promoting student participation in campus administrative activity, and providing opportunities to develop social skills, all consistent with the university's mission. The Board of Regents classifies the segregated fee into allocable and non-allocable portions. The allocable portion approximates 80% of the total fee and covers expenses such as student health services, intramural sports, debt service, and upkeep and operations of the student union facilities. Respondents did not challenge the purposes to which the university commits the non-allocable portion of the segregated fee. The allocable portion of the fee supports extracurricular endeavors pursued by the university's registered student organizations or RSOs. To qualify for RSO status, students must organize as a not-for-profit group, limit membership primarily to students, and agree to undertake activities related to student life on campus. During the 1995-1996 school year, 623 groups had RSO status on the Madison campus. To name but a few, RSOs included the Future Financial Gurus of America, the International Socialist Organization, the College Democrats, the College Republicans, and the American Civil Liberties Union campus chapter. As one would expect, the expressive activities undertaken by RSOs are diverse and range in content, from displaying posters and circulating newspapers throughout the campus to hosting campus debates and guest speakers, and to what can best be described as political lobbying. So these are all forms of speech, which is how we're even getting this cause of action. And I assume a state school. RSOs may obtain a portion of the allocable fees in one of three ways. Most do so by seeking funding from the Student Government Activity Fund administered by the ASM. Student SGAF monies may be issued to support an RSO's operations and events as well as travel expenses central to the purpose of the organization. As an alternative, an RSO can apply for funding from the General Student Services Fund, GSSF, administered through the ASM's Finance Committee. A student referendum provides a third means for an RSO to obtain funding. In one of three ways. So the first way is seeking it. Most do so by seeking it from the Student Government Activity Fund. As an alternative, they can apply for GSSF. Okay. And then the third way is through the student referendum. While the record is sparse on the future of the university's program, the parties inform us that the student body can vote either to approve or to disapprove an assessment for a particular RSO. One referendum resulted in an allocation of $45,000 to WISPIRG, WISPIRG, during the 95-96 academic year. It is inevitable that government will adopt and pursue programs and policies within its constitutional powers, but which nevertheless are contrary to the profound beliefs and sincere convictions of some of its citizens. The government, as a general rule, may support valid programs and policies by taxes or other exactions binding on protesting parties. So this is kind of like an analogy, comparing it to taxpayers and excise and taxes. Within the broader principle, it seems inevitable that funds raised by the government will be spent for speech and other expression to advocate and defend its own policies. The case we decide here, however, does not raise the issue of the government's right, or to be more specific, the state-controlled university's right to use its own funds to advance a particular message. The university's whole justification for fostering the challenge expression is that it springs from the initiative of the students who alone give it purpose and content in the course of their extracurricular endeavors. The University of Wisconsin exacts the fee at issue for the sole purpose of facilitating the free and open exchange of ideas by and among its students. We conclude the objecting students may insist upon certain safeguards with respect to the expressive activities which they are required to support. Our public forum cases are instructive here by close analogy. This is true even though the Student Activities Fund is not a public forum in the traditional sense of the term, and despite the circumstance that those cases often involve a demand for access, not a claim to be exempt from supporting speech. The standard of viewpoint neutrality found in the public forum cases provides the standard we find controlling. Okay, so the standard is part of the analysis. So I'm going to say it starts here, where they define the standard. Probably involves insisting upon certain safeguards by the payers of the student activity fee. We decide that the viewpoint neutrality requirement of the university program is in general sufficient to protect the rights of the objecting students. The student referendum aspect of the program for funding speech and expressive activities, however, appears to be inconsistent with the viewpoint neutrality requirement. Okay. We must begin by recognizing that the complaining students are being required to pay fees which are subsidies for speech they find objectionable, even offensive. The Abood and Keller cases then provide the beginning point for our analysis. While those precedents identify the interests of the protesting students, the means of implementing First Amendment protections adopted in those decisions are neither applicable nor workable in the context of extracurricular speech at a university. The proposition that students who attend university cannot be required to pay subsidies for the speech of other students without some First Amendment protection follows from Abood and Keller cases. Students enroll in public universities to seek fulfillment of their personal aspirations and of their own potential. If the university conditions the opportunity to receive a college education, an opportunity comparable in importance to joining a labor union or bar association, on the agreement to support objectionable extracurricular expression by other students, the rights acknowledged in Abood and Keller become implicated. So, college is like unionization and bar membership. Okay? It infringes on the speech and beliefs of the individual to be required by this mandatory student activity fee program to pay subsidies for the objectionable speech of others without any recognition of the state's corresponding duty to him or her. Yet recognition must be given as well to the important and substantial purposes of the university, which seeks to facilitate a wide range of speech. So these are the state interests. In Abood and Keller, the constitutional rule took the form of limiting the required subsidy to speech germane to the purposes of the union and bar association. The standard of germane speech as applied to student speech at a university is unworkable, however, and gives insufficient protection both to the objecting students and to the university program itself. Even in the context of a labor union, whose functions are, or so we might have thought, well known and understood by the law and the courts, after a long history of government regulation and judicial involvement, we have encountered difficulties in deciding what is germane and what is not. Those cases were only described, so I don't really know what. I don't really know how they're using the term germane. The speech the university seeks to encourage in the program before us is distinguished not by discernible limits, but by vast unexplored bounds. To insist upon asking what speech is germane would be contrary to the very goal the university seeks to pursue. It is not for the court to say what is or is not germane to the ideas to be pursued in an institution of higher learning. Just as the vast extent of permitted expression makes the test of germane speech inappropriate. Interesting. Inappropriate. Where was I? It is all but inevitable that the fees will result in I don't know where the heck I just was. And just as the vast extent of permitted expression makes the test of germane speech inappropriate for intervention, so too does it underscore the high potential for intrusion on the First Amendment rights of the objecting students. It is all but inevitable that the fees will result in subsidies to speech which some students find objectionable and offensive to their personal beliefs. If the standard of germane speech is inapplicable, then it might be argued the remedy is to allow each student to list those causes which he or she will or will not support. Any university decided that its students' First Amendment interests were better protected by some type of optional or refund system, it would be free to do so. We decline to impose a system of that sort as a constitutional requirement. However, the restriction could be so disruptive and expensive that the program to support extracurricular speech would be ineffective. The First Amendment does not require the university to put the program at risk. the university may determine that that its mission is well served if students have the means to engage in dynamic discussions of philosophical, religious, scientific, social, and political subjects in the extracurricular campus life outside the lecture hall. If the university reaches this conclusion, it is entitled to impose a mandatory fee to sustain an open dialogue to these ends. The university must provide some protection to its students' First Amendment interests, however. The proper measure and the principal standard of protection for objecting students, we conclude, is a requirement of viewpoint neutrality in the allocation of funding support. The parties have stipulated that the program the university has developed to stimulate extracurricular student. So that's kind of like the only imposition. I keep sort of hearing is that there's viewpoint neutrality. The parties have stipulated that the program the university has developed to stimulate extracurricular student expression respects the principle of viewpoint neutrality. If the stipulation is to continue to control the case, the university's program in its basic structure must be found consistent with the First Amendment. It remains to discuss the referendum aspect of the university's program. While the record is not well developed on the point, it appears that by majority vote of the student body, a given RSO may be funded or defunded. It is clear to us what protection, if any, there is for viewpoint neutrality in this part of the process. To the extent the referendum substitutes majority determinations for viewpoint neutrality, it would undermine the constitutional protection the program requires. The whole theory of viewpoint neutrality is that the minority views are treated with the same respect as are majority views. Access to a public forum, for instance, does not depend on majoritarian consent. That principle is controlling here. A remand is necessary and appropriate to resolve this point, and the case in all events must be re-examined in light of the principles we have discussed.